This is not a clown show.
Did I refuse to accept the mail? Yes.
Sir, you can't do that.
I can refuse to accept any mail that comes to me.
Excuse me, Mr. Hurst.
Excuse me, I wasn't finished.
Excuse me.
I wasn't finished. I wasn't finished. She cut me off.
You, Mr. Hurst. I'm not going to have this.
Your Honor, she cut me off.
I'm not going to have this.
Talking.
Plaintiff admitted that too.
All right, guys, this sovereign citizen just went full clown mode, claiming he's a living soul and spewing all the classic nonsense we've come to expect. But the best part? The judge actually laughs right in his face. Here's the deal. This guy owes the plaintiff money. Plain and simple. But of course, he denies everything and acts like he has no idea what's happening. He ran up a bunch of credit card debt and now pretends he knows nothing about it. You seriously can't make this stuff up. Let me know in the comments if you think he actually believes his own nonsense. Now let's dive in and watch this judge completely lose it on him. This is one you don't want to miss.
We are on the record calling 2-1-170-598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. Your appearances.
Good morning, Your Honor. May it please the court, Suzanne Strickarts, P44018, on behalf of the plaintiff.
And your name, sir?
Kevin Hurst.
Okay, where are we on this file, people?
Your Honor, we had a pretrial. You opened up a written discovery. We did send discovery out. We did receive it back, apparently unopened, indicating there was a written on the envelope itself. It had written, I'm reading here, I do not accept your offer to contract, all rights reserved, UCC 1-308, signed, and then it was a return to sender, Judge.
All right, Mr.
So we attempted to do discovery anyway. So.
Mr. Hurst, did you refuse to accept the mail?
Did I refuse to accept the mail? Yes.
Sir, you can't do that.
I can refuse to accept any mail that comes to me.
This is what we're going to do. One of the things she sent you were requests for admissions. If you do not provide proper answers to those requests for admissions, they are deemed to be conclusively admitted. Do you understand that, sir?
Objection, Your Honor.
Do you understand what I have said?
No, I don't.
All right, here it is. I open written discovery in this matter. You have a right to whatever legal position you want, but you do not have your own set of court rules. Among the things that the court rules provide when written discovery is open is that she can send you requests for admissions. Those requests for admissions are in writing and they must be answered under oath and in a certain time frame. If they are not answered and filed in accord with the court rules, then they are deemed to be conclusively admitted. You will not be able to contest those things. And that was what was sent to you, sir. And that time to start running those started with the day they were mailed to you.
Your Honor.
You don't want to accept it.
I'm not even sure. I do not have any understanding of this is my debt or not. They just coming with these allegations. I'm trying to see and verify if it is. When they called me the first time, they should have sent out verified documents stating that the original creditor and who it was and that I truly owe this debt.
Well, Your Honor, I just indicate that we did attach to those.
They already,
excuse me, Mr. Hurst.
Excuse me, I wasn't finished.
Excuse me.
I wasn't finished. I wasn't finished. She cut me off.
Mr. Hurst. I'm not going to have this.
Your Honor, she cut me off.
I'm not going to have this.
The judge might not think this is a clown show, but the moment this sovereign citizen joined the Zoom call, it turned into a full-blown circus. Seriously, this guy can barely string a proper sentence together. It's like he skipped English class to become a master of legal gibberish. And that way he said refused at the start. I don't know if you guys caught that, but I was dying. And let's not forget, if he had just accepted the mail from the prosecutor, maybe he'd actually know what he was being charged with. But nope, he's out here winging it with the sovereign citizen script like that's somehow going to erase the law. It's honestly wild how they cling to this whole I don't recognize your authority nonsense, as if the court is just going to go, oh my bad, you're free to go then. Like, no dude, that's not how reality works. I swear these people just do not get it. I don't know if it's ignorance, delusion, or something else entirely, but they're completely disconnected from how the world actually functions. Let me know if you guys agree or if I'm being too harsh. Now let's dive back in and watch the judge literally laugh in this guy's face.
Oh
You will
my
speak
goodness.
one at a time.
I can't finish my
You
statement.
will speak one. Don't interrupt me again, Mr. Hurst.
Go ahead, sir.
Why, thank you. You will speak one at a time. You will not interrupt each other. You will not interrupt me. Do you understand what I have said? Mr.
Yes, sir.
Hurst?
I don't understand anything.
Okay, fine.
I don't even understand why I'm here.
I'm going to mute
I don't
you.
even understand what's going on.
I'm muting Mr. Hurst, and I will let Ms. Strickard say what it is she wishes to say. Then I will unmute Mr. Hurst and allow Mr. Hurst to speak. Ms. Strickard, you were responding, Mr. Hurst.
Yes, sure. I was just indicating that we did attach the account statements, the full chain of title and seller data sheet to the packet. So even though there was no requirement, we did want to provide that to the defendant. And so that was in, all of those materials were in the packet that was rejected, Judge.
Well, let's let Mr. Hurst respond.
Okay, so the understanding that I have is that they should have contacted me 5 days after they should have gave me documents 5 days after they contacted me about the alleged debt. I told them I have no recollection of the debt. Yeah, I don't even know enough information to admit or deny the allegations to the debt. So if they're accusing me of this debt, I would like to ask them a few questions so that they can verify that this debt even belongs to me. And that's why I refused the packet, because I don't know if they're trying to contract with me or not. I didn't know what it was, so I sent it back.
All right, let me explain it to you again. Whatever political views you have,
I had no understanding that they were sending me these things. They didn't even tell me that they was going to send me. In the last court date, did they say, or did she say, we're going to send you something?
sir, I opened written discovery. That allows you to serve written discovery. That allows her to serve written discovery. And she did so. If you elect not to receive it, then that's on you. That's the risk, and you bear the risk of that. But I would urge you, and let me tell you, as I told you at the beginning, you have an absolute constitutional right to represent yourself, but what you do not have is a right to your own set of court rules. You may not be frustrating the court rules, sir, by refusing to accept mail. If that's the choice you make, then that's the choice you make, and you will have to live with the consequences of that. I would urge you, sir, perhaps you might want to get counsel, because I don't think you understand the process, and I'm not at all sure you understand the consequences of the choices that you are making. However, as I indicated, you have an absolute constitutional right to represent yourself. I would urge you to get counsel. So I'm going to give you another date. And sir, she is going to do what she does to represent her client, and you're going to do what you do. And if the court rules cut against you, then so.
Honestly, that sounds like a fair deal to me. If this guy wants to ruin his own life, then hey, go right ahead. But if he has even a shred of common sense left, he should be sprinting to find a lawyer and keeping his mouth shut in the meantime. After that speech from the judge, it should be crystal clear, even if I were as clueless as this guy, that getting a lawyer is probably the smartest move. But let's be real, we all know what's coming next. He's going to do exactly what we expect, keep running his mouth and digging his grave even deeper. Because here's the thing, sovereign citizens don't seem to care about consequences. I mean, let me know if you guys disagree, but I genuinely think they believe they're above the law. Not just the law, but the courts and, honestly, reality itself. I don't know if it's the state of politics, conspiracy rabbit holes, or something else, but these people are getting more extreme, and it's honestly kind of concerning. If something doesn't change, we're going to have sovereign citizens trying to buy groceries with monopoly money next. Actually, I wouldn't even be surprised if that's already happening.
I got a question. They are claiming that this debt belonged to me. Would they have to produce all the proof and verify that this debt belongs to me?
The plaintiff has the burden of proof, Mr. Hurst.
That's right. So she have to produce the proof that this debt belongs to me, right?
She has the burden of proof.
Okay. Thank you.
All right.
Judge,
I'm sorry, Ms. Rickards?
Your Honor, would it be possible for us to receive a motion date for, say, mid-July?
let's give him one more opportunity.
Oh, you want me to resend the packet, Judge?
I want you to resend the package. And sir, let me urge you as strongly as I can. So receive and open the package. Because if you do not, the request for admissions will be deemed to be conclusively admitted. The lawsuit, as a practical matter, will be over.
A fitting way to wrap up this entire circus performance. This man truly evoked a feeling that admitted Gil right away and didn't even bother to appear. That is essentially the same as stating, "Yeah, I did it," and then avoiding the court. His strategy was so awful that it's almost impressive. It seems quite obvious to me that he was just acting foolish. After all, he was merely expecting the court would magically erase the sum he owed the credit company. Warning, that's not how it operates. In actuality, the creditor may begin pursuing your earnings, bank accounts, or even place a lien on your property as soon as the judgment is resolved. However, who needs to be aware of that? YouTube legal advice is helpful, but in all honesty, sovereign citizens are evolving beyond the courtroom. Sideshow. They are a real issue. I understand that we enjoy watching them on YouTube and other platforms, but these individuals waste court time, clog the legal system with pointless files, and act out about hypothetical gaps while the rest of us bear the repercussions. Just picture yourself as a defendant in a legitimate case, stranded behind a stranger who claims to be a free resident with no legal responsibilities. It's really absurd, really, and their stupidity can also affect real life. Sovereign citizens have occasionally refused to pay taxes, driven without a license, or even squatting in other people's homes because they think they are exempt from the law is, quite honestly, unreal. It's quite hazardous. I think the judge's response was rather amusing, but I also want to know what you guys think about the actual issue these sovereign citizens have with the rest of us. In my opinion, it's pretty dangerous, and I'm not sure if it's political or not, but these people really need to calm down and receive harsher sentences. Thank you so much for watching, and please remember to use the like button and subscribe for more videos like this. Be careful, and I'll talk to you in the next.
Do you understand what I have said to you?
Yeah, I understand. I got a question. Should they have sent me something before they send me this package since the last court date?
Sir,
to verify that?
Sir, they're not required. If you think you need some information, you have the right to seek discovery too. But you can't tell them how to litigate their case. The same way
so she's going to send me a packet, and I'm going to send her back a packet as well, right?
No, you're going to do what you choose to do. She's going to send you again those requests for admissions.
Well, you said the
Don't interrupt me again. We had this conversation before, didn't we?
Sorry.
We had this conversation before.
Go ahead.
As a courtesy to you, she's going to send you the request for admissions one more time. You will either accept the package or you will not. You will answer and serve the request for admissions in accord with the Michigan court rules, or you will not. And then if you do not, then those things will be deemed to be conclusively admitted. If you choose to send written request for discovery, you have a right to do that too. You can send written interrogatories, request for production of documents, and request for admissions. Same as her.
All right, guys. So apparently this idiot actually accepted the packet. I mean, I just called him an idiot, but you know, maybe his last two brain cells decided that might be a good idea. But now he's going to be back in his next appearance. In this appearance, you're just going to have to see what he says. I mean, it's just so stupid. The judge actually laughs at him to his face. But with all being said, let's go ahead and dive into the next appearance here.
All right, we are on the record. This is 21-170-598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. Your appearance.
Good morning, Your Honor. May it please the court, Suzanne Strickhartz, P44018, on behalf of the plaintiff.
And what is your name, sir?
Kevin Hurst.
Okay. All right.
I do hereby reserve all of my rights, waiving none, not to be compelled to perform under any contract or commercial agreement that I did not enter, knowingly, voluntarily, or intentionally. I do not accept the liability of any compelled benefit or unrevealed contract or commercial agreement without prejudice.
Is there anything else you want to say, Mr. Hurst?
That's it.
All right. All right, where are we on this file?
Judge, discovery's been completed. Motion for summary has been filed. We are looking for the court to assign a date.
Okay, let's get you guys a date. Mr. Hurst, do you have the motion for summary disposition filed on behalf of the plaintiff?
It looks like this.
What's that?
It looks like this.
Yeah, I'm asking
Okay, yeah.
you first if you received the motion for summary disposition filed by the plaintiff.
Do I have it?
Yes, sir.
Yes.
Okay, so let's set you a date for hearing and we'll move on. Does July 26th at 10 o'clock, does that work for everybody?
Yep.
Yes, Your Honor.
Okay, July
Thank
26th at 10 o'clock, we will hear the plaintiff's motion for summary disposition. Sir, if you wish to file and serve an answer or to that motion for summary disposition, you must do so within the terms provided in the Michigan Court Rules. We'll hear the motion July 26th at 10 o'clock. Again, sir, if you want to file an answer, be sure to serve both the court and the counsel for the other side.
All right, guys. So now the part that we've all been waiting for. This idiot finally sent in his motion here, and I'm just going to leave it up to you guys. This one is super hilarious, and the judge's reaction, I just love watching this. I've honestly watched it a few times now, and it just doesn't get old. Let's go ahead and dive in and watch the judge's reaction.
All right, the court has had an opportunity to review the pleadings here. I was particularly interested in the request for admissions that was served by the defendant. Request for admission number 3. Does the plaintiff admit and have proof that the allegations against the respondent are true and accurate with all documentation being verified, signature and seals? These were admitted. Does number 4, does plaintiff admit and or have proof that the statute of limitations has not expired to collect on his alleged debt? Plaintiff admitted that. Does the plaintiff admit number 6 and have proof that the respondent had a meeting of the minds with Credit One Bank pursuant to the contract agreement in respect to full disclosure, and that said contract contains no elements of fraud by Credit One Bank? The plaintiff admits that. In number 7, does the plaintiff admit and have proof that Midland Credit Management purchased this contract from the original creditor and is now the new owner of the alleged contract and of the said debt that is owed? Plaintiff admitted that. So what we have is we have an admissions by our defendant of the validity of the contract, admission by a defendant that Midland creditor is a proper party plaintiff. And then we have in our request for admission number 8, does plaintiff admit and have proof that Credit One Bank did loan their credit to respondent and that the respondent is only obligated to pay back in money to Midland Credit Management? Plaintiff admitted that too. I also note for the record that having reviewed the brief answer to plaintiff's motion for summary disposition, first of all, contrary to court rule, is not supported by an affidavit. 2.116G4 says that when a motion for summary disposition under C10 has been filed and served, the opposing party here would be the defendant, may not rely upon his pleadings, but must by affidavit or as otherwise provided in this rule demonstrate the existence of general issue of material fact. Again, I note for the record, no affidavit was submitted here. I think it's fair to say that the pleading filed by the defendant is somewhat obtuse. I quote, for example, from the 3rd page, the agreed upon proof of claim does not serve in place of the original account, for it is a conditional acceptance and not the foundation of an action, and does not become an original demand and amount to an express promise to pay the actual sum stated. In his first paragraph, the plaintiff, and I'm quoting again, plaintiff claims that the living soul utilizes an address in his answer, when in fact the address that is used there indicates that the living soul does not live at this address, but is receiving mail there. So the defendant has failed to appear. He has failed to support his brief answer to plaintiff's motion for summary disposition by affidavit as required by the court rule. The court has had an opportunity to review the pleadings filed on behalf of the plaintiff in this matter, and I'm satisfied. There's no genuine issue of material fact in this matter. Summary disposition is granted in favor of the plaintiff. If you'd be kind enough to send me your judgment under the 7-day rule, I'd appreciate